Keep going.
Okay. Happy birthday. Thank you.
You guys aren't gonna sing, right?
Where's your election training when I brought you cookies that
We
one
have Stallman
time?
come in and sing for us.
Oh, Joe. 66 or 7? 7. Wait, 7, yeah. And pause.
Actually, I don't know if I have it, but that's like, that's a minute past, so that was someone I
I don't know how many more years.
No idea.
Okay.
So, you want the door shut?
Oh, I can shut it. Are you guys ready to start?
I think that might be it.
Oh, it's 11:15.
Jennifer Hillshine.
Oh, no, she doesn't. She moved on. Well, I don't know if
She's not there anymore?
I don't know. She's no longer with that.
Right, I knew she was, but she moved up.
I don't know if you need to call to order. I'm going to do all your agenda.
Okay. Should we stand and say the Pledge of Allegiance? Normally do. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'm up. All right. Good morning. I'm Erica Egley. I'm with the Iowa Public Information Board. I appreciate you guys all being here today. We're going to talk about Iowa's sunshine laws, which are Iowa Code Chapter 21 and 22. And I'm going to first tell you a little bit about IPIB, where I work, and then I'll get into the different chapters. I know you guys many of you have had training already this morning. So to make this more interesting, rather than just sitting here and listen to me, if you have questions, ask questions. If you have, let's make this interactive. I think it'll be a lot more helpful for you, answer questions that you have. So let's talk about the things that you want to talk about instead of just listening to me go through my slides. So, and you don't have to raise your hand, just shout out whatever your questions. So first of all, I work for the Iowa Public Information Board. I am not your attorney. I'm not providing you legal advice. If you need legal advice, talk to your county attorney. I'm just throwing that out there. I am going to also be talking in very general terms. And so, if you have a specific issue where you might have a legal question, make sure you talk to your attorney about it rather than relying on my general information that applies to every government body in the entire state. So, first of all, the Public Information Board, we've only been around for about 11 years. We're created by the legislature to be an efficient and free legal resource for individuals, for government entities to get questions answered, to provide advice, to citizens and government entities to answer questions, and then we also take complaints. Anyone can file a complaint with us, and our board will review that for the legal requirements under Chapter 21 and 22. We're one of the few boards like this in the country, and so we're pretty unique here in Iowa. A couple things about us is we have jurisdiction over every government entity that's covered by Chapters 21 or 22, open meetings and public records, except for the judicial branch, the legislative branch, or the governor's office. We are also limited to addressing those two chapters. If something is interrelated to Chapter 21 and 22, we can look at it, but we are limited to those. We're also limited to things that have occurred within the last 60 days of an alleged violation. We can't look at things that have happened a long time ago. And we can issue declaratory orders that have the force of law. A lot of times we also provide advisory opinions to help government entities as they're going through addressing what they need to do under Chapter 21 and 22. So any person can bring that complaint. We get anonymous complaints, we get complaints from companies, we get complaints from people outside of the state. It doesn't matter under our code section. Also, our board ultimately makes the decisions. We have a board, I'll tell you who those are in just a little bit, but they ultimately are the ones that make the decisions about how to address complaints, how to adopt advisory opinions, those sorts of things. Any final board order is subject to judicial review. You can look for a review with the district court. Our board, there are 9 members total under the code. Currently we have 8. All of our members are appointed by the governor and then confirmed by the Senate. They serve 4-year terms, and we have representatives from the governments, we have representatives from media, and then we have representatives from just general citizen individuals. We have board meetings every month, typically the 3rd Thursday of the month, and we now live stream and archive all of our board meetings on our YouTube channel. Staff currently, we're a very small but mighty team. We have a staff attorney who's starting in 2 weeks, but there's 3 of us at the agency, and so we do a lot of work, just the 3 of us. So we have 2 attorneys, and then Brett also assists, but he is not an attorney at this time. So when you call us, that's who you're talking to. Currently, this is our process for how we address complaints. We will receive a complaint, we get them over the phone, we get them by email, and then we also have a form on our website. Once we get that, we look at it to see if it applies to Chapter 21 and 22. Sometimes we get complaints about barking dogs, neighbors that they don't like. We can't do a lot with that, so we have to not open those. But if we get something that could be related to 21 and 22, we will open it. Then we'll send it to the government entity and ask for them to provide additional information. We'll pull in information as needed to do an initial recommendation to our board about accepting or dismissing a complaint. If the board dismisses it, then that's the end of it unless they want to take it to judicial review. If they accept it, then under the code we work to try to put together an informal resolution process to address the issues that were identified for Chapter 21 and 22. Chapter 21 and 22 are primarily procedural types of chapters, so making sure that things are done correctly. If the parties agree to that informal resolution and all of the terms are met, then the board will look at it and they can choose to dismiss it. If the terms are met, they typically do. If there's an informal resolution that is not accepted by both sides, then we do a probable cause report to our board, and our board can choose how to move forward with that. They can look at what was done to address the procedural issues, they can administratively dismiss the complaint, or they could take it to a contested case proceeding. Any questions on IPIB? I went through that kind of quick because you guys have been here for 3 hours, so. Okay, you guys are gonna have to talk or something. All right, open meetings 101. So this is Chapter 21. So the key thing to remember with Chapters 21 and 22 is that our legislature has specifically declared in the statute that if there is ambiguity in the construction or application of the chapter, that we are to look at it in favor of openness. So if it's very clear what has to be done, you don't have to go any further, but if it's kind of ambiguous, it could go one way or another, you're supposed to look at it in favor of openness. The idea of Chapter 21 is so that your constituents and the citizens know how decisions are made. When the decisions are made, how the decisions are made, when you're considering these different things, so that they can be involved in their government and understand what you're doing. So under Chapter 21, any governmental body is subject to this open meetings. A government body includes, the easy ones are, county supervisors, or city government, or a board or commission that is created under statute. There's also advisory boards. If the board of supervisors or the city council chooses to make a separate kind of board, separate commission, bring in people, those will also be subject to Chapter 21 because they're created by statute or that legislative action by the body. Drainage districts, levy districts, those are all required 2080 agreements if there's organizations that are created through that. they're also subject to Chapter 21, that open meeting requirement. Oh, thought I fixed that. So it gets a little, task forces, subcommittees, again, this is where it kind of gets a little difficult sometimes to determine if they're subject to Chapter 21. So if it includes a majority of the board, so Board of Supervisors, I think you guys have 3 in this county. If 2 of you are on a task force, then that would be subject to open meetings because you have a majority of you on it. If you have a majority quorum, then it would be covered by the law. If it's just an advisory committee of like citizens and things like that, not necessarily created by a legislative action or other things, or they're just kind of investigating, not really making any policy decisions, then they might not be subject to it. It gets a little complicated. So I put together this chart, so if you ever wonder if it's subject to a government body, you can have this chart. So boards, councils, commissions, or other government body, advisory board or commission, or task force, if it was created by statute or 2080 agreement, it would be subject to it. If it's a multi-membered body, formally or directly created by that board or council or something like that. So if you have intergovernmental things, if you have multiple counties working together and they're formally created, those would be subject to it. If you have a drainage district or levy district, those under statute are required. Non-profit organizations, we get a lot of questions about non-profit organizations if they're subject to it. That's very limited nonprofit. Typically a nonprofit is a private entity created. They filed with the Secretary of State. But if it conducts gambling pursuant to Chapter 99F, or there's pari-mutuel wagering, typically those nonprofits would be subject to the open meetings as well. Yes, sir.
Okay, I've always been curious about this. Now, let's say, for example, that you said that if like, say, the supervisors, there's 3 of them, so a quorum would obviously be 2.
Sure.
Let's say, I don't know, Gary and Tracy are at Watermelon Days together. Do they have to file an agenda?
So if they are at Watermelon Days, that would be a social event.
Okay.
So there would not be any deliberation on public policy. So that would not be considered, so under the statute, if it's a ministerial or a social event, where there isn't any deliberation on policy issues, I assume they're just serving watermelon or working a booth or something, I'm not sure what watermelon,
Yeah.
That would be a social event. We sometimes recommend just to, if it's a social event like that where you know that the supervisors are gonna be attending it, sometimes we recommend, and it's not required, we say, just go ahead and post notice that you're gonna be at this social event, so people know. There's not gonna be any deliberation or things, but just so you know, I mean, you don't have to do an agenda, you don't have to do minutes because it's not a meeting, but just let people know. In smaller towns, sometimes it could very likely be that a quorum of the body ends up in the same grocery store at the same time. I mean, you can't really, that isn't something where they meant to meet there and things like that, but.
Well, the only reason I was asking was because years ago this came up with the Benton City Council, was you had 3 members of the same family happen to be on the council. And it's like, okay, if they're having and somebody said, well, they had a family reunion, didn't they have to be a meeting? I'm like, that's it?
So, no, so we'll get into specific definition of a meeting, but social events are specifically excluded from it, but you have to avoid, I would say that if they're at that family reunion,
Yeah.
maybe they want to make sure that they're not like all sitting at the same table.
Oh.
Kind of keep things, make it easy for people to know you're not doing city council business.
Can I ask a question on the
Sure.
advisory council? So for example, our county board, we passed the EMS levy. So there's an EMS advisory board. The board appointed these members, and now they're meeting monthly. And currently they have the 3 supervisors and myself. So we've been posting agendas, but moving forward, if they have their own secretary and all that, can they do that without me posting an agenda and doing all that, or do we have to still continue?
They would need somebody to do that. I mean,
Okay.
it doesn't say who has to
Yeah.
do that, but that body would be responsible for making sure that that agenda and minutes are taken.
Okay, because I have not I post the agenda and do all that, but we're trying to decide whether we're gonna continue having the 3 board members or push it down to 1 so that we don't have to do it.
Yeah, so that would be something, there's not any, the body itself, that advisory committee would be responsible for doing that. So I would say making sure that you put in policies and procedures to make sure it gets done.
With the bylaws and stuff. Okay, thank you.
All right, best practices, so even if it's a close question, is this subject to open meetings, is this not? I would say, it's better to let people know that these committees are meeting, that they're doing the agendas, what they're talking about. We had a complaint where there was a group working on ordinances that really impacted a lot of people in the community. Was it technically something subject to the open meetings? Probably not, but a lot of people were upset that these things were being decided without them being involved in it. And so, allowing the public to know about it and participate in it if they choose to, a lot of times makes it easier. They might not always agree with everything that's changed or what happens, but at least they are aware of it. So here, kind of to your question, what is a meeting? So if you are having a meeting, then you have to have that agenda. We'll talk about notice in a little bit, and you have to have the minutes. A meeting is, under the code, a formal or informal gathering of members of the government body. It numbers to constitute a majority. There has to be deliberation or action that occurs. Deliberation is basically talking about things within the scope of your policymaking duties. And that deliberation has to be within that policymaking duties. If those 4 things do not occur, then it is not technically a meeting under Chapter 21. So if you just have one person who is meeting with a citizen, talking about things, that wouldn't be a meeting under Chapter 21. That would be something separate. If you're meeting for a social event, you wouldn't have that deliberation or action, and there's no intent to avoid the statute, so that would not be considered a meeting. You have to have all 4 of those things for a meeting to occur. Any questions on that?
I kind of have one. So, we had a grand opening of one of our county conservation. We had a grand opening of one of our parks, and it was open invitation. It is a social event in a sense, but it's still a county event. Does that make a difference?
So if you had that open and, let's say, 3 of the Board of Supervisors or 2 of the Board of Supervisors showed up, that would probably be either social or ministerial.
Okay.
So it wouldn't necessarily be a meeting. I assume you're not having them up talking, deliberating about the future of the park. They're
No.
just there to say, this looks great, thanks,
Yeah, I think that's what they all said too when they came.
So can you,
Yeah.
and maybe you've got it in here, talk about the walking or the
The walking quorum.
walking quorum?
So that is a kind of an open question. The court has looked at it a couple times. So walking quorum, the idea of a walking quorum is you have one person meet with less than a majority of the board, or a couple people, and then they meet with another group that's less than the majority of the board. And so, can you create a meeting from that, all those separate meetings? The legislature has never taken up they've had legislation proposed, but they've never adopted it. The court has looked at it a couple times, said we had some questions about this. The legislature never adopted this. We're not sure we can read this into the statute. But then you also have, I think it was out of the Warren County, you had the meeting by proxy where the administrator was meeting with individual Board of Supervisors to specifically work on policy and was sharing what was learned in all the different meetings. That one, they sent it back to the district court to determine if there was a meeting. I'm not sure ultimately what happened with it, but that was kind of the closest they've gotten to finding the walking quorum. Another question that needs to be answered at some point is how can you create a meeting through email? And we'll talk about best practices with emails. But if you're sending something to everybody and everybody on the government body starts chiming in on the policy and deliberation, it's possible you could create a meeting that way through that informal. The question is whether or not you would have that temporal deliberation or not. So that's kind of a question that's out there. Does that answer your question?
I tried to read the Warren County stuff and it was fairly confusing.
It is a little confusing, yeah. So I would say, I think the biggest part of the Warren County one that the court was concerned with was that there was clearly an intention to avoid the open meetings law. So that, I think, is really what drove that opinion. Because they specifically did it, avoided having any of these discussions to remove entire departments and employees when they knew they were talking about it and considering it. So I think it was more of the intention to avoid on that one and utilizing the administrator. All right. So policymaking duties. So advisory groups, again, kind of this is the committee. So if you have groups that are working on policy things, if you have groups that are going to be specifically deliberating on different things, if they've been created by statute or not created by statute, it can get a little difficult. So just consider that what you're using those advisory groups for, because it can be a closed question. Probably you would want to look at.
What about like handbook committee meetings, when certain individuals are making those changes?
A handbook, I mean, is it something that ultimately will come to the board to make the decision?
Hopefully, yeah.
Yeah. So I mean, that, I don't know. I mean, unless it's created by the board, I'm not sure if they're doing policy that's specifically, I don't know who's on the handbook, if it's employees. If it's just employees, then you don't have your government body involved in it. So I don't know, I'd have to look. That's something that maybe you want to run by the attorney.
Yep.
All right, we had so we do advisory opinions. All of our advisory opinions are on our website for anyone to download. We had a question about, sometimes we get responses that, well, it wasn't an official meeting, so did we really have to provide notice and an agenda and all that? It was just a work session. Any time there is a meeting that involves a majority of the board or somebody subject to Chapter 21, unless it's an exempt session, you need to have that notice, agenda, and the minutes. It doesn't matter what you name that meeting. It needs to be open, and the requirements under Chapter 21 need to be taken.
So sorry, I'm the one with questions because I know all the board stuff. So exempt sessions, for example, you can't just call one out in the middle of the meeting and say we're going to go into an exempt session if it wasn't on the agenda as such?
Exempt sessions would be, so there's the Chapter 21 if you have a union. They're not subject to Chapter 21.
What about 20.9?
20.9, which is?
That's in the previous meeting, like the old attorney would call out 20.9 and they would just meet with, say that 3 board members in the HR make decisions, but they didn't post agendas and stuff like that.
So again, Chapter 21, the collective bargaining, there's different rules. That's kind of outside our scope.
Okay.
So there's different rules on when it needs to be open and not.
So I think that's kind of where we get into a lot of argumentative things on that portion.
So it could be a separate meeting. I'm not sure, again, it's out, we can't interpret 20. But we do get a lot of questions. Oh, they held this meeting that was exempt, we couldn't come to it.
Right.
And so, especially when you have a lot of bargaining going on with union, collective bargaining type stuff.
Is there a place under, in section 21 that covers meeting for
For
things like
exempt,
that?
you can't have an exempt session under Chapter 21 for a non-collective bargaining if it's related to the same issues. So, insurance, salaries, those types of things.
So it would be, if you had to go into a closed session, it would be cleaner to do it under 21 than to rely on 20.9?
So 20.9 would be based on your collective bargaining and your right to do that exempt session. So when it's exempt, it's outside of chapter 21, so closed session wouldn't come into it. It would be considered an exempt session. And, you know, the idea behind that is if you're gonna be negotiating collective bargaining, it kind of defeats the negotiation if the other side can listen to everything that you're talking about, so. But it wouldn't be a closed session, it'd be an exempt session under 20.9. And there is also an exempt session for non-collective bargaining under 21. I haven't seen any specific interpretation on, you know, can you have an exempt in the middle of a meeting or does it need to be separate? But I can look and see if I can find anything for that. So if you have a chapter 21 meeting, you need to make sure that you have notice of that meeting at least 24 hours in advance. And under chapter 21, I know that counties and cities have additional chapters, 331, and I can't remember what the city is, and that might have additional requirements. But under chapter 21, you have to have at least 24-hour notice. It has to include the date, time, place, and a tentative agenda. We get a lot of questions about tentative agenda. Basically, tentative is kind of a misnomer, because if it's not on the agenda, unless it's a sincere emergency, like the tornadoes hit a building or something like that, you can't add things to the agenda if you haven't provided notice for it. As well, notice of the meeting has to be sent to any news organization requesting it. There's no definition of news organization. I get that question a lot. You know, for IPIP, if anybody wants notice of our meeting, we just send out one email, and so we just add them to our email list. You know, so consider if that really is an issue about whether or not they're news or not. The notice also under chapter 21 has not caught up to this day and age. The notice has to be posted, physically posted at the government office. It needs to be accessible, and it needs to be where the meeting will occur, where the board resides. So it's unclear on the statute exactly if you post it on a bulletin board and then everything is closed. You post it at 4, your meeting's at 6, and then you close for the night, and so then people can't see it again until 8. We recommend, if you have that posting and your building's going to be closed, post it someplace like on the windows or someplace, also in the library or someplace where other people can get it.
What about just the website?
The website, you know, works. There's nothing, we also get questions, they haven't posted on the website, is that a violation? There's nothing in the code that requires on the website. I would say, I think the website is great. People most of the time now will go look on the website rather than on a bulletin board. Just make sure that you continue to provide it. If people have relied on that, don't all of a sudden
Well, like
don't
if
put it
there's a
on.
glitch, because I know we've had that happen where the website's down and then we posted it properly, but the time it goes on the website is questionable.
Yes, yeah. So under the code right now, there's no requirement for the web. I would say it's best practices if you have a website to put it on there. That's where people are gonna go. All right, what needs to be included in the agenda? There's several court cases on this. So just putting old business, new business, yada, 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 all that stuff doesn't do it. You need to make sure that it includes enough information for people in the community to know what you're going to be talking about. So we've had some complaints where they put police department update, and what they really knew that they were going to be talking about was eliminating some positions. So that didn't give notice to the public that those things were going to happen. So make sure that if you know what you're talking about, you don't have to put paragraphs and long sentences, but if you know you're going to be talking about a new building on D Street or something like that, you put new building on D Street, potential action, discussion, those types of things. A tentative agenda can be subject, again, it would require an emergency. So an emergency is not, we knew that they weren't going to like that we were talking about this, so we waited until the meeting to put it on the agenda. An emergency is where there might be safety issues that can't be deferred. There could be additional costs and destructions, such as if a tornado came and took the roof off the building and you needed to take action immediately, but you didn't necessarily have those 24 hours. If you can reasonably defer it to provide that notice and call a special session, you should do that. And again, the information must be reasonably sufficient to alert interested people on the subject matter to be discussed. And it needs to specifically state what will be discussed in open or in closed sessions. And the court has ruled on that a couple times. Okay, here's your question. Can members get together socially? Yes, but don't talk business, right? So the legislature had added in a provision to make it clear that people could go to political events, political candidate events, or civic organizations. But they didn't include any limitation on deliberation within those events. So it was ultimately vetoed by Governor Reynolds. But it doesn't matter because you're able to do that anyway, so long as you are not deliberating as a group during that event. You're attending socially as you're, so some best practices on that would be if you're all going to go to, let's say, the Rotary Club, you sit at different tables. Maybe you wait to talk to each other until you're at a supervisor meeting, but you could talk to all the other people. All three of you could be there socially. You would want to make sure that you're very clear that you're not getting together and talking about things that you're going to be talking about in the meeting. Again, if you know you're all going to like a county event, a ministerial or social event, just, hey, the supervisors are going to be attending this event. It doesn't have to be, yeah, so.
After the board meetings, and how can we gotta run out of the room separate, 3 different ways, or?
No, so, I would say, if after your board meeting ends, make sure that there's no further discussion about event, things that you've discussed, policy issues. You can talk about your grandkids, you can talk about the weather. Just, make sure, be very clear. Our board, once the meetings are done, they just try to make sure that there's no further discussion on it. We try not to have a quorum there for too long afterwards, but it isn't like you have to, as soon as the meeting closes, you have to put your head down and run away from each other. You're human beings, so, if you're speaking socially, sharing, just be very careful, because, people want to make sure that if there's things being deliberated, that it's in an open meeting. So I would say just be very careful about, appearances, even if there isn't something that would be done wrong. Just, maybe don't stay and talk for half an hour, 5 minutes, hey, good to see you, good luck on, that fishing trip that you're going on next week, or say hey to your wife, or, you can be social, you're human beings, you know each other, just be careful and be cognizant of appearances. All right, email. Again, this is a question. So far, we've had a couple cases come before our board. So far, we haven't had a case where there was a majority that were engaged in that deliberation on email. So I'm not exactly sure where my board would come on this. There's no case that's gone to a court yet, so we don't have an opinion from the court. But I would say be very, very careful about email and deliberation through email. Any deliberation should be done in an open meeting. That doesn't mean you can't, we send out our agendas to our board members ahead of time. They need that information so they can prepare for the meeting. That's just information provided to them. When we send that out, we send it through blind carbon copy. So that then when they reply to us to let us know they're coming to the meeting, they're not doing a reply all. I'm on a board for a theater group, and the board, sometimes somebody will put out a question, and then there's like 45 emails deliberating back and forth on what we should do. Do not do that. That deliberation should occur in an open meeting. I think the theater group should deliberate on that in their board meeting, but that's another story. I'll never win that. But just be cognizant of that. If you can send information to each other, you can receive information, just don't do that deliberation with a majority through email. Emails are public records, and so when somebody asks, you can get that. And we do get a lot of questions about, I got these records and it looks like they're talking to each other. Is this a meeting? So far, we haven't had one where there's been a majority doing that, but that's an open question. And I would say if we're looking at it, if it's ambiguous in favor of openness, I would say don't deliberate through email. Any questions on that? Minutes. So if you have a meeting under Chapter 21, there need to be minutes. And the minutes, there might be also other requirements under 331. This is just Chapter 21. Date, time, and place of the meeting. That's what was on your agenda. The members present, and the action taken at any meeting. So if there's action taken, votes must be recorded. If the vote was 3-0, you can just put, 3-0 or unanimous. If it was 2-1, then you need to say who was on the 2 side and who was on the 1 side. And then minutes, even if they are not the official, if you go through and the board reviews them and adopts them, as soon as they're prepared, they are a public record under all of our guidance. Also, it's not a substitute for publishing under 331, but we also recommend if you're putting your agenda on a website, put your minutes on the website and keep people up to date.
I'm sorry, as soon as they're
Yeah.
completed, so does that mean, like, approved by the board, like they saw if there's any
As soon
edits,
as-
or is it just?
As soon as they're typed up. So my deputy director does our minutes. As soon as he finishes those, as soon as he types them up, even his notes from the meeting
Right.
would be a public record.
Okay.
As soon as he types them up, if somebody asks for them,
Oh,
we
sure.
provide them.
Okay. But then we don't have to post them until they're approved.
It depends, 331, there's a time lane.
Okay.
If you don't have that publishing thing, then.
Okay.
So another thing we get on minutes, there are some questions about what to include in minutes, those types of things. And again, there's nothing in Chapter 21 that requires it one way or another. I know different groups like to do it different ways. But we do get, people do get very concerned when they feel like only one side is included in the minutes. So if you include in your minutes any public comments and you only include like part of it, or you editorialize it, or somebody says something mean about somebody else and it includes in the minutes, people really get upset about that. The minutes are the record of the government body. It should include the actions taken and what occurred at that meeting by the government body. Any additional information is not necessary to be included in minutes, aside from ordinances or resolutions or things like that.
So
That
like
would be action of the
public
body.
comments, like what if it's employees that come in and want to,
So there is no requirement under Chapter 21 to include public comments in your minutes. There's no requirement to include what the discussion was. So our minutes are, here is the case they're considering, here's who spoke, not what they said, and then here's who made a motion for this, seconded, and then the vote. That's what our minutes include, because that's the actions of the body.
it's cheaper to publish them than they're not. Saving money.
Yeah.
So, that's the other thing, and it's the responsibility of the body to make sure that those minutes are accurate.
So if minutes are published, and then maybe something inaccurate is found later, can those be retracted or changed? even
Those can be
months later?
changed. You would just want to indicate that it was revised and changed. With the publication, if it's something significant like how much money you're borrowing or terms of a resolution or something like that, you probably need to republish it. But if it's just like who voted here, or you had just a little error that isn't going to change the outcome, you wouldn't necessarily have to republish it. But you can revise it if an error is found.
And there's no time frame on that?
There's nothing in chapter 21. A question we get a lot is, do members have a right to speak at an open meeting? And there's nothing in chapter 21 that requires that public have the right to speak. If you put public comment on your agenda, then you need to, and people want to speak, you need to make sure that everybody is given the opportunity. Some places put time limits on each individual or total time that can be taken for public comments. But that is again up to the body, and it's not required under chapter 21 to require that there be that public comment. Again, comments do not have to be placed in the minutes. The minutes are only the actions of the public body. So just be careful and make sure that if you provide that opportunity, everybody's given the same opportunity. Closed sessions. Any questions on like the meeting, the notice, that kind of stuff? All right. Next time I'm bringing coffee. All right. Closed sessions can be held only by a vote in open session of 2/3 of the members of the body or all members present. And you have to specifically state the purpose for the closed session on the agenda and why it is. So there's very specific reasons you can go into closed session under the law. So you could review or discuss a record required or authorized by state or federal law to be kept confidential or as a condition to retain federal funding. One that comes up a lot for that is you want to submit a bid for something or something like that where it would be something that would be kept confidential. Again, you know, we want openness, but you have to be realistic, right? It doesn't do any good to bid if everybody knows what your bid is. So you guys probably don't have a lot of applications for patents. To discuss strategy with counsel on matters currently or may imminently be in litigation. Counsel has to be present for that, either physically or on the phone in some way for that to occur. The court has specifically stated that that needs to be done. If it is your county attorney, regularly everybody knows that that's your attorney. You don't necessarily have to identify them. But if you have like an insurance claim or something and the insurance company has provided you an attorney, you need to make sure at some point that is identified as counsel for that particular issue. You guys, if you have a licensing exam, disciplinary investigation, you guys probably don't have that. If you did, that you could go in to discuss those things. You probably don't have students, contested cases. I don't know if anyone in here would have specific law enforcement matters.
Yes.
Okay, if you have law enforcement matters disclosed would enable law violators to avoid detection or facilitate that, you could go into closed session for that. To evaluate professional competency of an individual whose appointment, hiring, performance, or discharge is being considered, that person has to request that it go into closed session. If that person doesn't, wants it in open session, it has to be held in open session. But just because they ask for a closed session doesn't mean that you have to hold it in closed session. We get some of those, we get complaints where they chose not to go into closed session to have that discussion. When I went through my interview, all of us were interviewed in open session. So just because I request it, that's ultimately up to the board or the government body to decide to go into closed session for that. And then to discuss the purchase or sale of real estate. Again, you don't want people to know what you're wanting for it or what you're offering for it. But once that transaction is completed, then that is no longer confidential. If you have security proceedings, emergency type things, that also can be done in closed session. Again, those are things that need to be kept confidential. Otherwise, it could harm your protecting, your security procedures. And then you guys, if you have a county hospital, patient care, process improvements, those types of things can be done in closed session.
Benton County Supervisors.
There might be other sections of the code, these are just the sections under 22, or 21, that allow for you to go in to talk about closed session. So if you're in closed session, you've made the vote in open session, I would say a roll call vote is necessary because you need to know how everybody voted. Once you're in closed session, no additional topics can be discussed. There was a recent court case, the DeWitt School Board. In that case, basically the school superintendent asked for a closed session for his review. Once they went into closed session, he said, all right, now let's talk about all this crazy stuff going on in our school district, and really just went kind of off the rails. They released that recording because they did not agree with what was done there. And it was, the court was quite taken back by the scope of what was discussed in that closed session. The session has to be recorded and detailed minutes must be taken. So the full comment about just the actions of the board, those types of things in regular minutes. For a closed session, you really need to take detailed minutes of what is occurring in that closed session, and it needs to be recorded. Those records then would have to be retained for at least 1 year, and they're not a public record. Courts have looked at it and have not released the recordings, even if there was a violation, because it is not a public record. They need to be kept confidential, but somebody who, so let's say you only have 2 supervisors at the meeting, the 3rd supervisor was sick, couldn't make it, that individual would have a right to listen to that recording of the closed session, because if they'd been here, they would have been in the closed session. So it can be limited, but it needs to be people who had a right to be in that closed session to listen to that tape.
Can we talk about that tape for just a second?
Sure.
Audio
I don't know.
or audio and video?
It does not.
The code's pretty specific in one spot where it says audio. Tape.
Okay. So, I mean, but you would, so most places just tape it.
Just audio. Because I don't, in reading that numerous times, it never mentions video. It just says audio.
Video, so you have to remember that this code was first written in the 70s and hasn't had a lot of revision since then. So, as long as you have an audio, you need to have it. That was, I don't know.
That's what it says.
So you have to record it and you have to take detailed minutes. If you have action that is going to be taken pursuant to that closed session, that action you need to vote to come out of closed session, you need to take that action in open session. There's nothing in chapter 21 that requires you to go into a closed session for any reason. Again, that's the choice of the government body to go into closed session. Nothing is required. Again, chapter 21, there might be something in another code provision. A lot of school stuff, hospital stuff might require it. But chapter 21 itself doesn't have that requirement.
I have a final action question. So the action must be taken, in open session. So the example of like bidding on something. How does that action look if we are purchasing a property and we're saying we're putting in for $10,000 an acre? That's going to be our bid. What does that?
So you would come out of closed session, you would say, I'm Shelby, I make a motion that we put in the bid pursuant to our confidential amount discussed in closed session.
Okay.
You wouldn't have to give that
Right,
amount, because that's, right.
Okay.
But you would need to take that action for you to go do that bid. This is a new provision. It'll come into play in July of 2024. This was in the boards and commissions bill that was signed into law a week or 2 ago. And this is an amendment to chapter 21.8. This is kind of the electronic meetings. Previously, you could only have an electronic meeting if there was no way you could have an in-person meeting, and you had to state in your minutes why it was necessary to do it electronically. They've now required it that every governmental body shall, that means you have to provide for hybrid meetings, teleconference participation, virtual meetings, remote participation, or other hybrid options for the members of the government body to participate in official meetings. So, you'd have to at least have a conference call option if one of the government, let's say you're somebody on one of your commissions goes down to Texas for the winter, that allows them to participate in it. What they were finding with boards and commissions is making it easier for people to participate. It is necessary to provide for that. They have the definitions of hybrid, remote, teleconference, and virtual. Those are new definitions. This was just passed. But it does specifically state that these options are for the members of the government body. I've had a question if that means that you have to provide links for everybody to participate that way. It says for the members of the government body.
I have a question with that. So
Yeah.
for example, if it's one of the board members and they call in on the board's only phone line and tie up that phone line, is that, we probably shouldn't do that because that's open to the public during the meeting, correct? The supervisor's line, like if somebody from the general public wants to call in.
Oh, okay.
So like that call, for example.
So I would say, you can get teleconference type options, or some other way for them to.
Way of communicating.
Or if you have, we just moved to Google Meet. So all of our board gets a link to it if they can't come to Des Moines, that they can participate on that Google Meet. But then our meetings for the public are live streamed unless they're specifically participating.
So could you say, we're not gonna do in-person meetings, we're gonna do all our meetings by Zoom going forward? And here's how the public can watch.
There is no longer a requirement to state in the minutes why an in-person meeting would be impossible or impractical. I'm not sure that you would want to move to fully virtual, but there might be, so for instance, some of our committee meetings we'll do virtually because we have board members in Dubuque and other places, and it doesn't make sense for them to drive all the way to Des Moines for a 45-minute meeting. So we'll do those committee meetings virtually. But I don't know if you would want, that's not, that would be a decision for the government entities, not for me. This is what it says. You have to make sure that if you are doing virtual, it's still an open meeting. These are still open meetings. People have to be able to see what's happening. But again, this takes into effect July 1, so you have some time to think about it. Exempt sessions, so this is for anyone who is not subject to Chapter 20. You could have these exempt sessions for basically employment type conditions. And again, I'll look to see if it's something that it could be. It has to be a separate meeting or something. I haven't seen anything specifically on that. All right, that is open meetings. Any questions, comments, thoughts? So we need to stand up and do some jumping jacks?
No,
No?
no.
All right, chapter 22. Here we go. Open records. So, open records. So in addition to all of the government bodies, every official and employee of those government bodies is subject to chapter 22. And what it means is that anytime a record is created, which has a very broad definition of any documents, tape, or other information stored or preserved in any medium of or belonging to the government body, is a public record. So notes that you're taking at this open meeting are a public record. The videos, if you create a video, that would be, if you record something, that would be, all of that becomes a public record. Electronic communications, emails, websites, texts. If it relates to the government business, it's a public record. Even if you use your personal cell phone. So please don't use your personal cell phone for public business, because then you still have to provide it. Records relating to investment of public funds. every government body has to designate a lawful custodian and publicly announce who holds that responsibility. Typically, there's a link, an email address, something like that. Who that custodian of the records will be. So, best practices. Do not use texting or other informal means to conduct government business. We have had several complaints about people using their phones to text about government business. Their personal cell phones, personal emails, those are public records if they relate to your government business. If you are creating a text message, that is a document. And if it's related to anything that you're doing for the government, that would be a public record. It gets difficult. Anyone in here who's a custodian could probably talk about how difficult it is then to say, well, I need to look through your phone to find all of the public records. I need to look through your personal email that you've been using for government business to get all of your public records to respond to this request. So I would say do not, there's nothing in the code that prevents you from using to text or those things, but I would say it would be better to have a policy not to use personal cell phones for those types of things.
Benton County Supervisors.
I thought I was calling the auditor's office.
Hi Brenda. No, you have to call 472-2365.
Yes. 2365, thank you.
You're welcome, bye-bye.
So,
It was an easy one.
so that's, you know, my board is really struggling because these are coming up more and more. The issue is in chapter 22, there's no specific retention requirement. So I don't, if you have a retention policy in your county and it relates to anything, then you would have to follow that retention. And then you could, if there isn't a record, one of the cases we had, the record was deleted. They were texting and they deleted it. They said they didn't have space on their phone. Then the records request came in, and at that point, there's no record. There was no retention requirement, there was no retention policy, there was no policy about not using their phone. There's, you know, once it's gone, there's not a lot you can do. If there had been a retention policy and they didn't follow it, then that would have been a violation. So just, you know, really think about what kind of policies you want. And again, you have to think about what that looks like when somebody makes that records request and you're like, well, I deleted it last week, but I swear I did it before I got this. So just kind of think about what that looks like. The other thing is, you know, oh, did you have a question?
Yeah, there's a Central Iowa Detention has 40 members on their board.
Yeah.
So 20 would be those outside members, if they use their phone, let's say there's 20, well, there's not 20 there. How many people are usually there? 17 or 18?
What are you trying to get at?
What's? We've
What
got,
is a quorum?
yeah, you've got a quorum,
Yeah.
but you've got outside, well, I'm trying to figure out whether you can use your phone or not.
Oh, people call in, people are there in person, they call in, or they Zoom.
So that, using your phone to call in, there would be the record that you made the call, but you wouldn't necessarily, the concern is when you're using your phone, your personal email address, so it's not something within the government, or you're texting on your personal phone and it's not something that is within your, you know, you don't have a government phone. Just calling into something or just using your phone to like log on to a website that's saying you're there doesn't necessarily create that record outside of what the government has.
Okay.
So you know, we've had, somebody made a records request once for the employees in a department all of their cell phones, everything on their cell phone, because they had their cell phone with them at the office. Just because you have your phone with you at the office doesn't make that everything on there a public record. What makes it a public record is that it's related to the government business. So if you're using your phone, if you're emailing so I have a Gmail account, if I'm using my Gmail account to communicate with my board outside of my official government email, that doesn't mean that I avoid public records with those. Those emails would still be public records that would need to be provided, even if I'm using my personal email. The emails to my mom wouldn't be public records unless, I guess, she was working for me or something. But, just my checking on her and those types of things wouldn't be public records.
In that case, so we're gonna say you have your government email on your personal phone. You only conduct business through your government email, not through your Gmail. So is everything on your phone then public record, or just
So as long
those
as you're
work emails?
staying just in that government email, and it's the record itself, whether or not it's a public, so if it's
Yeah,
related.
so it's not like, it's not done text message, you literally just have your work emails.
Right,
on-
so sometimes, like if you have, like a web-based, so you're checking, but it's on a web-based Gmail, so you're not necessarily downloading things on your phone. You would still have access to those government emails. You could search those, the custodian could search those through your IT department.
Yeah, so it's not done through any other thing on your phone.
You're just
So
logging
your
in.
entire phone is not access to public record, it's just, it would still be the only thing that you're using for government stuff. Like the email, like if you're not.
Right, but
texting
if so if you're downloading, let's say Iowa's email is a web-based system, so I can go to any computer, but there's still, all of it is saved in the government server.
Mhm.
And so if there's a request, it's all on that government server to be searched. So that doesn't necessarily, the only thing that would be on my phone was that I might have gone to that website, but I don't have anything specifically downloaded on my phone. So the issue is making sure that you can pull those government records. But if you have I haven't used it for a long time, but like Outlook used to download all your emails. And so maybe some things are on your phone, some things are on your work computer, some things are on your home computer. That's where, those are all public records as long as it's government business, instead of keeping it in one place. So be really cognizant about that.
So as long as nothing is physically downloaded, it's.
So to clarify, we are using Office 365, so it is
All on.
cloud-based, all on, it's not the old pop.
So if somebody said, I want.
Where you would download emails.
Right, I want all of the emails related to this meeting, or this training. You could do a search on that government and find those.
So then I have a question for appointed boards. They're using their personal emails and their personal phone numbers, still conducting county business.
Yep.
And
Those are
so
public
it
records.
just opens their stuff up to be combed through, unless they make a separate email just for
Yes.
board business.
Yes. And that would be a better policy, is to have.
Right.
I mean, Gmails, you can do free, I don't know, there's a
You
lot
can
of
do
free
multiple.
emails.
Yeah.
So what's the definition of government business? So for example, if Shelby texts me and says, let's have lunch today, and Shelby and I work together for the government, is that, you know what I mean? Have we conducted government business per se?
That, I probably wouldn't necessarily be problematic.
Okay.
But, I mean, if you're setting up a meeting to talk about, so you're saying, hey, let's meet at 2 p.m. to go over the new job description for, I don't know, or we're gonna go over the park stuff, and you're texting back and forth, that, is that government business. If you're just meeting socially to go have lunch, that probably isn't. But again, just kind of keep that in mind. It's very, very easy to create a public record. Okay. If you guys find a way that works really well to address that kind of issue, share it with us, because I know a lot of places are kind of struggling with how to do that, specifically with some of these outside commission members or things like that where they don't have a specific government email.
And then, sorry, just really quick, the retention policy, you said, for instance, within 60 days is when a complaint would come to you?
Yeah.
I was just trying to think of
Yeah.
what would be a good retention policy.
Well, I mean,
to hold
so,
on.
I know League of Cities, and I think the counties might have a retention
Okay.
policy. It's gonna depend, like finances, you're gonna have
Right.
tenured minutes forever.
Yes.
I
I was just thinking on the text thing,
Yeah.
because that's like the most,
Yeah.
probably
So-
difficult.
15 minutes.
Yeah, I mean, just, something to think about.
Mhm.
All right, any other questions on that? Anyone have any?
Yes, going back to the text thing.
Oh, yeah.
If I text my board and say, hey, remember the meeting tonight is at a different place than normal or something like that, that's technically a government.
Yeah.
So then is it on them to also follow our retention policy and keep that text? Okay. Fantastic.
Email might, yeah. Email might be better.
Yeah.
It's easier to search. All right. Did I go the wrong way? Okay, we put out an advisory opinion last year. We were getting a lot of questions about cybersecurity and records requests. So a records request, you have to respond to any records request that comes in. It can be in person, on telephone, electronic, or did I get them all? Or in writing. With email, and you also, they can be sent anonymously. They can be sent from anyone. You don't necessarily know who is sending you records requests. Sometimes, a lot of times you will. It might be the same people. But if you get an email from like, I'm going to take down your government at gmail.com, and there's all kind, they say records requests, and then they have all kinds of links and attachments. You have to try to respond to that records request, but the only way to respond to it would be to click on those links or download those attachments, and the IT guy is sweating right now just listening to this. I can tell. So we put out an advisory opinion if entities government bodies want to put together a policy about how to address email, electronic records requests. You can't prohibit people from making electronic records requests. You can't prohibit them from making it in person, in writing, or on telephone. But our board felt that with the cybersecurity concerns, with the extensive malware and ransomware going around, that government bodies should be able to put some restrictions on how they handle electronic records requests. And so we put out, this is just a portion of the advisory opinion, but talks about, if somebody sends that email records request with all the links and attachments, under this, your policy could be that you respond, we'd like to, we've received this, but we need you to put the specific records request clearly and concisely in the body of the email, or we can't respond, we cannot download attachments. And the other thing is that if they send those, a lot of times they're just going straight to spam, so they're never received. So we also put in some best practices for people to make those records requests. So those are things to consider if you want to put policies or things up on your website about how to do that. The other thing is some places have portals or online forms where you don't even have to deal with those kind of things. They just fill it out and then it is submitted and you don't have to worry about as much of that cybersecurity stuff. The only thing is you have to make sure that you allow people to make those records requests in other forms, in person, in writing, by telephone, or electronic. But you can put restrictions on those electronic as long as you give them the option to do it the other way if they want. Any questions on that, concerns, thoughts? Okay, we don't want anyone to get ransomware from responding to our records requests. The question we've gotten, can somebody make an anonymous records request? Yes, the definition of person under Iowa code is very, very broad. The only thing that they have to do is they have to give you enough information that you can respond to them and get them the records request. But they don't have to show their ID, they don't have to sign something, they don't have to, give you their name and address. Iowa's Chapter 22 does not have any distinction between people who live in Iowa, people who don't live in Iowa, between individuals and corporations. Any entity, person, unidentified person can make a records
So they
request.
don't have to sign for it.
They don't have to sign for it.
Thank you.
If you have a form, some places have a form so that they can keep track of it, which makes a lot of sense. You can ask them to fill out the form, but if they don't want to fill out the form, they don't have to fill out the form. The best thing, if you ask them to do a form and they won't do it, they just want to give it to you, fill out the form yourself. And then you have your documentation to keep your records requests in order. I think this is probably the number one question we get. How much time does a custodian have to respond to a records request? In the code, there is a section that says a reasonable delay, good faith delay is allowed to determine whether record in question is a public record or confidential. A reasonable delay for this purpose ordinarily should not exceed 10 business days and cannot exceed 20 calendar days. The Iowa Supreme Court has said this is just a recommendation. They will look, you can't possibly have a specific time frame based on the wide array of records requests. So there is no specific time frame that you have to meet. If you don't get it done in 20 days, that isn't a violation of Chapter 22.
And if, like, general practice, what we normally do, we'll respond right away, that we'll be working on it, because sometimes it's specific, if they want it off of our software, like for vendors, or.
Yep.
And I always tell everybody, just at least respond that you're working on it.
That is best practices. Yeah. So when you get that records request, do a response. If it's something like they just want a copy of the minutes, right? You could respond, hey, I've received this. If it's on your website, you can say, you could download it, and don't just say on the website, give them a link. Make it, or attach it. It's something like that, just, you could quickly do it. Don't charge them, make it easy for them. We've had records requests where they've asked for every single email from every employee for the last year. That is a records request that's gonna be quite extensive. It's gonna take a lot of time, and for a small 3-person office, that's pretty.
If it's a big copy, we do charge for copies.
Yeah. So the court has said, it says this 20 days, but that doesn't mean if you don't get it done in 20 days that you can't claim confidentiality. It doesn't mean that it's a violation. You have to look at the records request. If you're, and they also recognize that, in Iowa, we've got very small cities where there might be a clerk who only works 1 day a week. Various things. There's too many dynamics to have a specific time frame. They just want you to work in good faith and work on it. Communication. We rarely ever get complaints from people that they communicated with me about my records request and they kept me up to date. But it just took 25 days, even though they told me it was going to take 25 days. The things that they will look at, and the court has looked at, this is a case from 2023, the Bellin versus Reynolds. They look at how promptly the requests and follow-up inquiries were acknowledged, so similar to what you were saying, providing assurances that you're going to provide the records, explanations about why they might not be immediately available. So if you have to do a search with IT, or something might be off-site storage, something like that, or it's an extensive thing, ask them if they want to receive the records as they become available. So if they have a very extensive request, do they want them as they come available, providing updates, and also providing the person when to expect the records. So these are specifically the things that the court identified that they look at to determine if you're working reasonably to provide those records. Just failing to respond and not doing anything, at some point the court will look and determine it's an implicit refusal, and that is a violation. Supervision and fees. So again, requests don't have to be in person. People are allowed to come and examine, copy. It gets difficult with electronic records sometimes. You're not gonna probably allow somebody to come and just sort through your computer to find what they want. But if you have like records books, recorder's office, assessors might have record books that people wanna look through, they can do that. The custodian or somebody designated by them needs to be there, just to make sure that nothing happens to those records. Those are government records that need to be preserved. So you can have reasonable safeguards, provide a suitable place, and provide a reasonable number of copies. That's under the code. You can charge reasonable fees for the services of the custodian of copies. The statute also says that reasonable fees are based on actual costs. So actual costs, we have a couple advisory opinions on what that means, but actual costs would be what it actually costs you to do it. So if the person who's collecting the records makes $20 an hour, it would be that $20 an hour for all that time that individual spent. You don't get to do benefits and all that kind of stuff, just their hourly rate. You're not supposed to make money, but you don't have to necessarily stop everything. You still have to do business. Copies, I'm still seeing sometimes that they're charging 50 cents for a copy. If you're charging more than FedEx, Kinko's, or Office Max, that's not based on your actual costs. Our actual cost for our little office is 1 cent per copy, if we charge for that. So you need to look at those actual costs. If you're communicating with the person, if it's something very simple, again, the legislature says if it's 30 minutes, simple thing, just provide it for free as best you can. If it's something that's going to be more extensive, you're allowed to charge those actual costs. If it's something, I would say best practices, even if they don't ask for it, if there's going to be a fee, let them know about it ahead of time. So if it's a really extensive records request, provide an estimate of what you think it's going to be, and I would say require prepayment. I've heard from multiple places that they get the request, it's kind of extensive, they go to all the trouble to put it together, and then nobody comes to pick it up. So you are allowed to require prepayment of a fee, just be consistent in how you do that. Estimated expenses must be communicated, and again, the fees cannot exceed the actual cost. So you do your best to put together an estimate. Once you get everything compiled, if the estimate was higher than what it actually cost, you would give them a refund of that, because it has to be based on the actual cost. Legal review. So a lot of times somebody will make a request for emails. They want, so you get a stack of like 200 emails. You can't charge the cost of the attorney's time for going through all 200 of those emails under Iowa code. You need that initial person, the custodian or somebody to go through and identify what could be potentially confidential or need redaction. There are legitimate things that could need that redaction. Once those are identified, you can send that to the attorney. You could charge for that time that the attorney does. The code just doesn't allow you to have that charge for that attorney's time to go through all 200 of those potentially. They have to be identified as potentially confidential. Doesn't mean you can't send all 200, you just can't charge the person for those. Databases, the software itself is confidential, but the records contained on a database can be non-confidential or a combination. So, if you have personnel information, their hire date wouldn't necessarily be confidential, but the birth date would be confidential. That doesn't mean, so you wouldn't be able to provide the birth date, but you could provide information about the hire date. And just because it's on a database doesn't mean that there's no record. You could print off that information. You can't withhold something just because there's some confidential information and non-confidential. So if there's a way to redact information and provide the record, you should do that. Just keep that in mind. Just because one portion of it is confidential doesn't mean that the entire thing can be withheld necessarily. Again, anyone can examine. You can't prevent examination by contracting it out. So let's say you have all of your records on the cloud. So you have a contract with that cloud. You can't say, oh, well, we no longer have custody of that because it's stored in the cloud. That would be a violation. And geographic computer databases, that one, I know that there are requests for specific types of files on that. And that is something that is kind of a difficult question. I know there are things going through the court on that. Basically, when we've looked at it, if it's something that's provided to others for free or at a certain cost, it needs to be based on the actual cost then. The thing to keep in mind is that if you provide a public record, if somebody makes a request for a public record and you provide it to them, if the next person walks in and asks for that public record, they need to be given it. If it's non-confidential for one person, it's non-confidential for everyone. This gets a little difficult when you have people come in who have maybe a right to that record outside of the public records, but they say they want to make a public records request for that document. That would be, if I walked in and asked for it, you would tell me it was confidential, but because they are the mother or the homeowner or something like that, they might have access to it. You need to be very clear that you're providing it to them, not as a public record, but because of their relation, because of who they are, their relationship with it, or that sort of thing. That gets a little complicated sometimes, but you need to be very clear, because a lot of times people just say, I want this public record because I'm the mother of this child, and so just make it very clear. I'm not providing this to you as a public record. I'm providing it to you based on your relationship because you have a right to it for this reason. That's something that you would probably want to definitely work with your attorney on to make sure that's handled correctly. Oh, I keep going the wrong way, sorry. Oh, maybe I have that choice. So confidential records. 22.7 has 75 reasons why a public record could be withheld as confidential. I'm not going to go through all 75. There might also be some additional rules that affect confidentiality. Juveniles in crime, sexual abuse, those kind of things might come into play. Most common ones, you guys probably don't have medical records, trade secrets. If you have vendors or something like that that have submitted bids or other things like that, and there's a request made for them, you can give them, say, hey, I've had this request, give them a certain amount of time, they could go seek an injunction for that trade secret. Work product of an attorney related to litigation by or against the government body. That specifically is in the code, but there's also attorney-client privilege is very much honored and unless it's been revoked or unless the government body has waived it, the attorney-client privilege does not makes that document confidential, even though it's not specifically listed in 22.7. Peace officers' investigative reports, I'll talk about that one in a little more detail. If you have crisis intervention report by the law enforcement agency, appraisal information concerning sale or purchase of property for public purposes prior to the announcement of the project. Again, like the closed session, once it's completed, there's no longer a need for confidentiality. If you have some federal funding, some grants, things that have to be kept confidential, you could lose your funding, that can be kept confidential. Homeland security. Those types of things can be confidential as well. Confidential personnel records. Certain things are confidential: age, race, sex, address, social security number, home telephone numbers, reason for sick leave. And there are specific things in the code that are public: that employee's name, their compensation, their total compensation, anything of value, employment dates and positions held, educational background and previous employment, so basically their resume or their application, And then if the person resigned in lieu of termination, was discharged, or demoted as a result of disciplinary action, that could be public as well as the documented reasons and rationale. Otherwise, if it's in their personnel records, the court has said that is categorically confidential. So if it's not one of these specific things and it's in the confidential personnel record, it can be withheld as confidential. There's no balancing test or other things like you'll see in other parts. And that was the ACLU case. Police investigative reports. This is an area that gets a lot of time and attention. So this is the code provision. It has peace officers investigative reports, privileged records or information in 80G.2, which is basically about the law enforcement officer. Portions of electronic mail and telephone billing and records, if that information is part of an ongoing investigation. And then the date, time, specific location, immediate facts and circumstances surrounding a crime or incident shall not be kept confidential under this section. So that always has to be provided unless there's a very unusual circumstances where there would be some safety issues or jeopardize danger and safety for somebody. The electronic mail and billing records can only be held confidential until either there's the prosecution or an indictment or information, or the statute of limitations for that crime has run. So there's 3 separate parts of this. You have to provide date, time, specific location, immediate facts and circumstances. Those need to be provided. A lawful custodian can release more. Lawful custodian always has discretion to release more. Victims are generally not confidential unless they're child victims of sexual crimes. Fatalities, again, that would not be confidential, but you would want to make sure you let the next of kin know first. And that would be a reasonable reason to delay providing that. Electronic mail and telephone, this hasn't necessarily gone to the court much, but once that either the person has been convicted or a statute of limitations is run, this would no longer be confidential. It's only while there's that ongoing investigation. The key area where there's a lot of gray area is the investigative reports. Investigative reports are generally confidential, but it's not a absolute like confidential personnel records. It requires an analysis before finding that it's confidential. And this is the test, it's kind of wonky. The public officer is being examined, so basically it's communication to a police officer. It's in their report, it's in their investigative report. The communication was made in official confidence, so you're talking to the police officer while they're doing their investigation. And then the public interest would suffer by disclosure. So if you can find that the public interest would suffer by disclosure, then you can withhold that as confidential. So things like 911 calls from a suicide or something like that, definitely, a video camera from going into a domestic dispute or something like that, there would be really no the public interest would suffer by their disclosure. But there has to be that 3-part test before holding it as confidential. So this is just a case where the court further looked at it. They brought a Chapter 22 claim. They wanted copies of the police investigative report. And so this is where the district court was going to give them all of the records so that they could make their case that they need to receive the records. And the Supreme Court said that, no, if the records are the subject of the suit, you have to determine whether or not they should be released or are exempt before you provide disclosure. So this was just kind of, an interplay. There's a lot of interplay between civil suits and public records. Just a reminder that public records retain their confidentiality until there's a determination by the court that they could not be held as confidential. Another way to, that might be confidential is communications from persons outside of the government. So if it is, somebody sends an email, I want to report such and such to election person, or I want to share that I saw this about somebody. If it's a communication that's not required by law or rule, so they're just a citizen reaching out, and the lawful custodian could reasonably determine that if they release this information, it could keep people from wanting to share that information, wanting to disclose. You could silence people by, if they knew that what they reported was going to be made public. You could keep that confidential. If you could redact parts of it without being able to identify that person, you certainly can do that and should do that. It gets difficult when you have like phone calls where you can't really disguise the person's voice, or based on all the information they provided, it would be easy to determine who actually submitted that information. So you kind of have to look at those types of things as well. Draft records, this is one that comes up.
Back you up to the investigative reports.
Yeah.
That you touched a lot on police. What about like if an employee would send like a complaint, like, I think my coworker is stealing, I want you to look into this, or I have this documentation what about like that?
Would that be in their personnel records?
Well, what if it started with an email, like, hey, can you look into this matter?
I would have to look at that one, because the investigative reports are police investigative
Right.
reports.
Right.
So, as far as internal investigations, I mean, there's the confidential personnel records. It wouldn't really be persons outside government, because you're saying they're an employee in the government. So, I don't know, I'd have to look at that one.
Okay.
That might be one for your attorney to look at for you. So draft records, this one can be a little confusing. It's not like a rough draft of a document you're working on. It's basically, the idea is that they want to allow you to consider different policy things without the fear that if nothing happens with it, that people can get a hold of it, right? So if you're thinking about, let's say you're trying to decide if you're gonna, bring Dave & Buster's into town or something like that, so you're doing some research on it, but nothing is ever sent to the Board of Supervisors, nothing is ever taken up, you could keep that policy, that's probably not a good policy, but that idea could stay confidential because it was never provided to the government entity. There was nothing, no actions taken on it. So it's that kind of thing that they want government entities to be able to think about these things without fear that until they're further along in the process, that they would be disclosed. So I put together a little chart. Basically, if it's provided to a public official authorized to adopt or execute that policy, it loses any of that confidentiality. If it's used in the actual formulation or recommendation, maybe it's a previous draft, but it's used as part of the final draft, it wouldn't have confidentiality. If it just outlines an idea, beginning of it, then it might retain that confidentiality. But basically, it's not rough drafts, it's policy issues, investigating policy, potential policy type things. And we're almost done. You guys are great. Release of confidential records, basically, because something could be confidential doesn't mean that it has to retain its confidentiality. It could be released by the lawful custodian, it can be released by the court, or another person authorized to release the information. So that sometimes there can be a decision to release that confidential information. Settlement records, if there's a legal dispute, a summary of the dispute, and then a copy of that settlement becomes public record. So you do have to provide that summary unless the settlement agreement has that summary in it as well. So that is a public record once it's completed. Penalties, there are penalties for civil lawsuits. Courts can issue injunctions, they can assess damages for persons. These are the current damages. If somebody knowingly participated, they can increase the damages. Damages are not assessed against officials who voted against the violation, refused to participate, engaged in efforts, or relied on formal opinion of the Attorney General, the advice of an attorney provided in writing or memorialized in a meeting, or the Public Information Board. So then the government would pay those penalties if there are any assessed. If they're under 22.10, good reason and good faith belief, the court shall not assess any damages if that person incorrectly balanced that confidentiality. So that comes into play like for that investigative report. If you did the balancing test and maybe the court disagrees with you, that they wouldn't look at assessing those violations. If you're acting in good faith, you have reasonable belief in the advice that you had, those types of things, then they won't provide, the court won't assess those penalties. Okay, real quick, just gonna go through best practices and then we're done. You guys have been great. So promptly acknowledge the request, provide contact information of the custodian or the designee, provide an approximate date by which they will, they should get an estimate for actual costs or release of the document, and inform the requester of any expected delay. Communication is always the best. Again, if you get that lengthy text, attachments, links included in what appears to be an email's records request, request them resubmit that request in the body of an email. Clearly and concisely, if they push back, you can remind them that they can submit their records request in writing or in other means. Make sure that you are articulating the limits of those in a consistent and uniform fashion. If you get an extensive email request, records request, or something like that that could impact cybersecurity, make sure you're working with your IT and your attorney quickly to get some estimated costs, concerns, those types of things. If there is no record, Iowa Chapter 22 does not require you to create a record that does not exist. So if there is no record, clearly articulate that there is no record. Again, you don't have to create it. If a record is being withheld due to it being confidential, I would say that best practices would be to articulate that you're withholding something as confidential and the reasons for it. If it's an easy, simple records request, 30 minutes or less, provide it at no charge. If it's an extensive request, get prepayment, provide that good faith estimate. If we get a complaint about the estimate, we will ask you how you came up with that estimate. What was the hourly rate? What was the various things? How did you come to that estimate? That's what we'll look at. So make sure you can document that. And that is it. You can go to our website, all of our complaints, all of our advisory opinions, everything is on our website. Attorney General also has some sunshine advisories. They're a little older, but some are still very applicable. And then your attorney for your government body is always a great person to rely on. And then ISAC or other organizations that you might belong to are also very helpful. So that is all that I have, but I'm happy to answer any additional questions anybody has. You guys are, if you've got 5 hours of training today, you guys are kind of monsters. Yes?
How many cases do you deal with monthly?
Monthly, well, I mean, right now, as of yesterday, this year, we had 47 active cases. Last year, we had 100 and, I'm gonna get the number wrong, I think it was 134 last year. Cases that were opened and worked through the process.
How many cases do you get that you say?
I only sort of track those. The only ones that we don't ever do anything with are if they're not within our jurisdiction. So dog bites. I got one about teenagers not wearing hairnets at Taco John's. Mother-in-laws. I get those. I can't really help them. But otherwise, if it is related to Chapter 21 or 22, we will open it and send it. for review and a response from the other side, or from the government body.
So in other words, if nobody knows who else to complain to, they complain to you?
I think I think when people, so the thing I didn't expect in this job was, people think that we have all of the information about Iowa, because we'll get a lot of questions about Iowa, or they want every record from other places. So they think we're the public information clearinghouse. And then, yeah, we get, I've had hairnets, I've had barking dogs, I've had mother-in-law, I've had, just anything that somebody can complain about, I've probably seen that email. So. Any other questions, thoughts, comments?
When you were talking about timelines, talking about records request timeline, is there a timeline for meeting minutes? I got asked that question. Like, is there anything that says they have to be up, posted at a certain time or within a certain time?
So, chapter 21 does not have that, but I think 331 has requirements for publishing and that sort of thing. And again, that's kind of outside ours. I can't remember if it's 10 days from the meeting or.
We always do it like the bottom of something. Yeah. So,
You don't have to request.
yeah. I get that section.
If there's nothing else, as far as the board goes, I'll ask for a motion to adjourn.
Second.
Okay, moved and seconded, call for vote, Primer, aye.
Human eye. Usually aye.
How's Tracy?
She's doing better, she's going around, getting better, on the other side, it's a lot more walking and stuff.
Is it two? By that one?
About 1 minute till.
I got 3 minutes still here.
She went ahead.
Yeah.
57 on the,
It's now time.
So she's doing, maybe it's a little adjusted. Where he works, his place, and he says that, she's coming around here, she's coming back, everything's going good, she's getting more exercise, getting more strength and stuff, so. Yeah, she's doing more physical therapy and everything.
And Davis Implement used to be right east of the courthouse.
No, we didn't, she was
Years ago.
It's kind of weird. What do you want going back and forth with the, no, she'll back up, radiation treatments. Because she was working at the line. Yeah, because they couldn't do it down there, because they wanted to do it in the same place. But if, yeah, she had talked about other stuff that was coming in, some stuff was working, and she just felt tired. She was just trying to.
Are you ready? It's close, it's close. Depends on what watch or clock you're looking at. So shall we stand and do our pledge of allegiance, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Had a chance to look the agenda over. It's not what you call lengthy.
yeah. Make a motion to approve the agenda.
Second.
Okay, it's been moved and seconded to approve that agenda. Call for vote, Primer, aye.
Human eye.
Usually aye.
And the item on here is to discuss and approve hiring an HR assistant. I think yesterday you wanted to get a copy of the year-to-date.
Which was sent to me.
It's sent to all of us, yep.
Are you still holding off on those outside legal bills though? 'Cause you gotta take that into consideration too.
Holding off on what?
paying the Hopkins and Huebner invoice?
I'm holding off on it.
Well, there was one that, some of it was yours on that last one.
Was it just sent last week? I guess I didn't know.
I brought it up to you guys when we did the service area
2
amendment.
weeks ago. Yeah, I was thinking that was somewhere around $5,000, wasn't it? Yeah, so even if you'd include that $5,000, include a month's worth of expenses, did you do the math?
No, I haven't yet.
Okay, well, if you would roughly $5,000 off of that, including, I don't know what a part-time person would work, I just put 20 hours as a, hi Barb, as a thought, so if you take that $5,000 off, you're still gonna come out about 14,000 under budget. The year-to-date that you have shows 30,894 point.
But she still has her wages and stuff to come out.
Exactly, that's what I did here. I took her wages, her insurance, well, I think there was IPERS in there too, but, so I figured that. And so before the attorney invoice that Haley just mentioned, I had it at $19,194.48, which was 13.4% under budget. Is what I came up with, but you gotta do the math. So that's what you were looking for.
I figured her stationery, what she's got on here, would be more than enough to cover the part-time help for a month. And I don't think you don't need any more stationery for the rest of the 30 days.
I don't believe so.
Did get an email that from a concerned citizen that stated that, really wasn't comfortable to have a volunteer going through files. And I definitely understand. Definitely do. Should be an employee.
Yeah, I responded to that. If you decided there wasn't enough budget here, there's things not employee related that, if we did start it early, like
Yeah.
LinkedIn, setting that up, the website, preparing, doing research for safety committee meetings, things like that, so.
Excuse me, but how do we know? How does the public or the employees know that that person is not accessing our confidential information?
And that's why I think it's more important to have an employee versus a volunteer. You're right, Kara. Yeah. So.
I'm still thinking that it should all be done over in the auditor's office, because I'm not comfortable, obviously there's a trust issue, all these files there, and then are you gonna have a part-time person in your office? So then they would technically have access. It would be no different than the auditor's office keeping something like that.
But those files, I want to be specific.
The payroll, I know.
So, yeah, but
But
I mean,
I'm
the general
still-
public keeps thinking
I'm
we're,
still saying, she already has a copy.
Yeah.
I feel like there's such a trust issue with a lot of people in this county right now. Do I feel comfortable with you and some other person when we've already had issues with closed meetings? We already have issues with things going on behind the scene. It should be Nancy and you sitting down, going page by page, not you at nighttime, not you here by yourself. Nancy, two people should be present, and it should be someone who already has the charts and files, and yourself, or your part-time person, whoever you want to go over those. Because to me, that's gonna make sure everyone's being honest, there's not gonna be any question. If you wanna go over at any time, you go ahead and do that, schedule it with Nancy or your part-time person. Why does it have to come over here and you are the only one that's gonna have access to that?
If I may, that's not up for discussion. What is up for discussion is to hire a part-time
Right,
assistant.
but you guys were bringing up the fact that the part-time person would potentially have access to the
That's where our
records.
HR department is currently located.
Right.
And if we choose to do something different, we'll have to do that down the road. And that would be an agenda item, so.
Okay,
but-
just saying, it's no different than.
I get it.
Someone else having access
Sure.
in their department. And did you take that into consideration?
Of course,
You did.
of course, yeah.
So it's
And-
okay
and
for
that's
her
why she
extra
has
person
an
to have
intern.
access.
That's why she has an intern who is studying HR at the current moment. So that's
But
what
it's
she's
no
indicated
different than someone in
yesterday.
the auditor's office having access to those files.
Other than they're not studying, taking HR courses, so. But,
So just
okay,
said that
it's
we're
irrelevant
studying
right now
HR.
because it's whether or not we are hiring an assistant. That's what's on the agenda.
Okay.
So, gentlemen, that's what our decision is. And it's basically boils down to, are we going to amend the budget for 3 to 4 weeks for her to get her in before the first of
An amendment cannot possibly be done before June 30th.
the,
So if the money is there, you don't need an amendment, right?
oh, that's,
It's just
Well,
pull it
that's your
from a
budget.
different.
The board's in charge of the budget, not me.
yeah.
So previously, when I've asked about the budget, is I'm like, oh, if I'm over in background checks, let's say, but I have access in here, is that okay? And I've been told that's okay, as long as the bottom line, you aren't over. So it sounds like how you figured it and how I figured it, I will still be under. So I think because of that, that doesn't require an amendment, because it's still under the bottom
Alright.
line. Is
Can
my
I ask a
understanding.
question? Do you only have the area in your budget, bottom dollar, because of the amendment that you received for the new HR equipment, the new system? not
Oh,
equipment, the new system?
Karen, that's for next fiscal year.
But she
Okay.
did get an amendment in the beginning of the year for training and that kind of stuff. If that's the one you're thinking of.
So the money for the new HR system is not being utilized to hire?
Correct.
No, that's next year.
So, gentlemen, what do you want to do?
She don't have to make an amendment, right? If it's in her budget?
It's within her budget, I'm just saying there's still gonna be, I know she has an outstanding credit card statement and some things that have to come out, so I don't know what, that's, if she tells you she has it in there, that's between you and her, not me.
I'd hate to think you've got over $14,000 in credit card charges.
I also would hate to think that.
Yeah, because I don't think your limits are that high.
But then again, like Jill pointed out, we discourage end of the year fiscal spending, so what's that telling other departments? Do you want to set precedents to that? I mean,
Oh, that's been done for many, many years prior
not all
to this,
departments do that.
prior to this board coming on. So, yeah. Yeah.
You got it next year's budget?
Do I have it next year's budget?
In next year's,
Did I figure her in?
yes.
Yeah.
Yeah.
That
We
was
haven't done
approved.
that allocation or anything yet, but. But again, I would have a statement, if you would quit taking duties and things out of my office, you wouldn't be so busy, or I feel like you're doing way too much like what you're supposed to be doing. That's my 2
We-
cents, I had to get it out there, so.
I'm just following
We
the
get an
job
item
description.
on the agenda here.
But,
Let's-
but my employees need to follow their job descriptions too. And payroll is one of them, and payroll files, keeping them up to date, is Nancy's job description. So if you want to discuss job descriptions, I brought them with me as well.
Even since you brought up the files, did the files get moved from
No,
yesterday?
because I checked with lots of other counties, and that list she had, some
So
of
the
them,
files were not moved like you guys had said was going to be done?
They come in yesterday, but there's some of them that aren't, that are supposed to stay with payroll. So,
So my understanding is that those are all coming to my office tomorrow. And is that has changed
we
from
are not
the
ready
meeting?
for that yet. Just like we said, we're gonna have more than one person look at this, and I'm still checking with a few things
So
before
just
I
to be
give them
clear,
up.
was there an action taken yesterday that said that those were gonna be moved to my office? And then you called me and said that will happen Thursday, and now that's not
I did call you
happening?
that, I did not.
No, but I showed you some conversations today, him and I are gonna be talking about some things.
I did not talk to Haley at all yesterday. I talked to Nancy. So she needs to be in on it. She's the head of the department,
Yes.
not Nancy.
I'm Nancy's boss.
I'm aware.
Okay. So when she tells me she's ready to move the files, you will get them.
So the action that was approved yesterday in the public meeting is not happening.
We didn't say a specific date. Do you guys not realize my office is busy right now doing elections? I'm not gonna have all the chaos of files getting moved at this particular time with voters at my
It
counter.
doesn't affect you, it's opening a drawer and putting them in a box.
Okay. We have an item on the agenda. It's not the files. It is to hire an assistant. And if you don't get the files moved soon, the assistant will sit there doing other items.
I guess I thought you guys were doing it after the election, but
That's what I thought
maybe I
too, so.
misunderstood it.
I thought it was being done yesterday.
Oh,
I
So
did
did
too,
Doug.
I did too, because that's, Tracy was pretty adamant on it.
Yes, he was, so.
I was
yeah.
not in there yesterday, what do you mean?
So, okay. But
So does, let's say we hire a person, does she have something to do till the files get moved?
Yeah.
You make it sound like these files are just gonna keep somebody busy all day long.
I'm sorry.
Well, I mean,
Yeah.
again, nobody's like grasping what,
Yes,
beating
Gary,
a dead horse.
we've talked about this, you know, there's other duties to be done, so, yeah.
Yeah, there's a variety of things and projects.
so but do you still have to do like the hiring process for an assistant?
What do you mean, do the hiring process?
The background checks, of course,
Well,
Hiring
like
committee?
post it and
yeah, it's already
have
been
people
done.
apply and,
Oh, yeah,
That happened.
oh, you've already got all that?
oh, yeah.
Okay.
That's why this was the name that was selected
They
after all
they
that.
did that action item in her closed session, I guess.
Oh.
We approved that.
And it was talked about hiring.
What do you mean we did that action
with-
item in the closed
That's what you
session?
guys said yesterday.
I said, we instructed her to look at it, just like we did Mark Greenlee years ago. We told him in closed session, he needed to be looking at getting somebody on, and you were there. But that is the same
But
scenario.
then, like we
Okay,
learned today.
we're
you have
back
to
to
take
this
action.
here. Let's act on it, or get the hell out of here.
Well, we already know she's gonna get her
She
way
gets
because
them the
she
first
already
thing.
asked Ben about her computers today,
She
so.
already-
So you guys probably already made the decision.
We have okayed her new budget, just as we have okayed everybody else's. So the question is, are we going to allow her to hire somebody before the fiscal year? Bottom line. Okay? And it shows that there is a surplus in her budget.
Spend it while you got it, right?
It's not the first time it's happened.
I've never done it.
Didn't say you did. Gentlemen,
I think roughly the cost is $1,000. Just,
If it's 3 weeks, I figured if it was $20, excuse me, 15 an hour, 20 hours, give or take, 3 weeks is $900. 4 weeks will be $1,200.
right, and added in the Medicare and FICA and all that. I tried to bump it up a little bit.
Right. So I was just talking gross.
Yeah.
We've made decisions on spending bigger money much quicker. Much quicker.
Can I ask, what seems to be the hesitation, guys?
Whether or
Either way.
not they're willing to step
Either way.
up and say she can hire somebody 3 to 4 weeks early.
I know it, but I mean,
It's like something
It's either a yes or a
stopping
no.
you. It's
Yeah, it's
like,
a
what's,
yes or a no.
why are you
Uh,
hesitant?
I
What
don't.
changed from yesterday? That's, I think that's what we're
yeah,
thinking,
yeah,
like,
there's a hesitation here.
they're not answering.
You know,
I don't know.
It's like they're put on the spot. I don't know.
I wanted to make sure it was in her budget, it wasn't over.
okay.
My conflict is right now is that she hadn't figured for first of July. Not now. That's my conflict right now. Even though it's in her budget, we agreed to first of July. Let Gary speak.
I don't see what the big deal is about 3 weeks. Just, well, start it whenever. Right now is a tough time. Haley's got the election. I'll do whatever you guys want to do. I don't really care. It's 3 weeks. It's not that big a deal.
Okay, what's the worst that's gonna happen if you go ahead and approve it? How about that question?
Okay, I'll make a motion that we authorize her to hire the assistant. And it's, bring her on board, she's got the money in there. So, that's my motion. The chair can do that. We need to get moved off dead center.
Second?
I'll second it.
Okay, it's been moved and seconded. I'll call for vote. Primer, aye. Beershank?
Aye.
Seaman?
Seaman, aye.
Okay, all right. Last item is adjournment.
Do I need to tell you the resolution number?
Oh, yeah.
It's a
Be a
resolution.
good idea, sorry.
2454.
Okay, very good. Thank you. So we need to sign that, so is there a motion to adjourn?
Motion adjourned.
I'll second that. Call for vote. Primer, aye.
Seaman, aye.
Beershank, aye.
May I ask a quick question?
Oh, of course. I am sorry, Barb.
That's okay, I'm just quietly off in my little corner.
Yeah, we didn't have the
Well, it has
public
nothing to do
comment
with
there, so.
this exact item that you just voted. My question is, if you're moving all of these files out of the auditor's office, are they going to be in a secure place?
Yeah, it's
Are
a
they in
lot.
vaults?
Ours are locked up in my office now too.
I know.
Yeah.
I know they're
Yeah.
secure up there.
Yeah.
Where they're being moved to this building? Are they secure here?
Yeah, my door has a code on it, and then they're locked with a cabinet with a key on it.
Okay, so this building doesn't look particularly secure to me either.
I would say personally that I don't believe they're secure here as they would be involved at the courthouse.
Wasn't there training today about discussing?
The courthouse, you would have to go up the elevator or break a window from the outside.
Yes, I'm very familiar with the courthouse.
Okay.
That's why this building worries me.
And then this is the, yeah, just like.
Yeah, the courthouse is much more secure than this, there's no doubt about it.
This is the offer for her.
Haley's office has a
What's her first name?
Julia, $15 an hour.
Vault.
and start date.
and then it goes down the basement. A lot of people